We have to discuss clause 4 of article 15 कि why clause 4 of article 15 came with the first constitutional amendment. और आप देखोगे पीटी में फर्स्ट कॉन्स्टिट्यूशनल अमेंडमेंट पूछा गया है. तो why first constitutional amendment came, why it was very interesting. So yesterday I was telling you that why we were discussing article 15, the clause 4 of article 15. Clause 4 of article 15 क्यों जोड़ा गया? Because this was a clash between, and this was landmark case in चंपकम दोरेराजन केस. देखो क्यों इंपॉर्टेंट हो जाता है कोई चीज. विच इज अ फर्स्ट? चंपकम दोरेराजन केस. तो जब भी इंपॉर्टेंट क्या होता है, कोई फर्स्ट केस है या कंटेम्प्रेरी है, लैंडमार्क है. तो चंपकम दोरेराजन केस इज द फर्स्ट एग्जांपल ऑफ अ क्लैश बिटवीन फंडामेंटल राइट्स एंड डीपीएसपी. एंड we know that why it was a clash of the fundamental rights and DPSP, because yesterday I have told you, because what was the issue? Madras government provided reservation in the medical college on the basis of caste. Madras government provided reservation in a medical college on the basis of caste. And why it was violating the fundamental rights? Because clause 1 of article 15, clause 2 of article 29, Champakam Dorairajan challenged the decision of Madras government on the basis of article 32 and on the basis of clause 2 of article 13. You know that why clause 2 of article 13? Clause 2 of article 13 protects every fundamental right. Clause 2 of article 13 says that no law can breach the fundamental right, and that is some sort of bulletproof. Clause 2 of article 13 is very significant. There is a clause 4 in article 13. But what is more important, clause 2? Why clause 2? Because that says that any law which breaches fundamental right or any law which is encroaching fundamental right shall be declared null and void by court. And how we can approach Supreme Court? Under article 32. Therefore, Champakam Dorairajan directly approaching Supreme Court. And why? Because this act of Madras government was violating the fundamental right of Champakam Dorairajan. Under clause 1 of article 15, which says that states shall not discriminate only on the basis of caste, race, religion, sex, place of birth, or any of them. Then clause 2 of article 19, any educational institution which is getting aid out of a state fund, they cannot discriminate the students in the admission only on the basis of, again, caste, religion, and on the basis of language. It means Champakam says that this is a violation of his fundamental rights. And since fundamental rights are enforceable, fundamental rights are justiciable, fundamental rights are enforceable and justiciable, therefore Supreme Court was bound to hear and listen the argument of justiciable and it is enforceable. Therefore Supreme Court adjudicated the matter of Champakam Dorairajan. And let us see what was the argument of Madras government. Madras government on the other hand argued that under article 37, it is an obligation of a state, it is a duty of a state to enforce the fundamental DPSP, directive principle of state policy, because it is a fundamentals of governance of this nation. But we know that 37 we cannot approach Supreme Court or High Court because DPSP is a non-justiciable, non-enforceable, and Madras government says that it's our responsibility to implement in the policy, in the law making. Therefore, it means on the basis of article 37, Madras government says that we are engaged in the welfare functions of the people. And that is the point. We know that whenever we are looking the clash between fundamental rights and DPSP, logically it became the clash between parliament and judiciary. Parliament and judiciary. Because Parliament is parliamentary executive, they are responsible for the well-being of people. It is obligation of Parliament and executive to implement DPSP. Because when India became independent, it was a land reform, it was this reservation that became tool of the well-being of the people. So automatically that clash became the clash between Parliament and judiciary, and we know that earlier our founding fathers, they had more belief in Parliament for a well-being of the people. Later I will tell you in Article 21 that is the reason our function of judiciary that was kept under limitation, because what we thought that judiciary should be only act on the principle of procedure established by law. So in our constitution we were given more power to the Parliament. Obviously Parliament was elected body, represent the will of the people according to principle of a democracy, although our constitution is supreme. But if you look the compare between three organs of the government, then automatically Parliament was given more power. This is not only in case of India, but that was in case of every democracy including US. Even founding father of US too, they were given more power to Parliament. Once I was listening to the interview of Kapil Sibal, he is a renowned lawyer. And you know that he said that we are in a country where we are living in the country, we believe in supremacy of Parliament. That may surprise you. Because you are reading out Constitution Supreme, and he is saying that Parliament is supreme. Then there may be confusion. Yeah, sir ने तो बताया था कि Constitution Supreme है, and the lawyer like Kapil Sibal is saying Parliament is supreme. What is the correct? From political perspective, Parliament is supreme. But for actual, because Parliament, executive, judiciary, every organs of the government, they are getting their power from the Constitution. So in case of India, from legal perspective, from technical perspective, Constitution is supreme. But from political side, since Parliament represent the will of the people, and nothing is more important than will of the people. Will of the people is supreme. On that basis, what he justified? Supremacy of the Parliament. And on the same account, see, Assembly says that because Assembly of Madras government, they said that here we want to implement Article 37, and under Article 37 we want to implement Article 46. And what is Article 46? A state will provide education for the weaker section of society and for the class belonging to scheduled caste and scheduled tribes. So therefore they are doing well-being for the scheduled caste, scheduled tribes, weaker section. The term weaker section only referred in Article 46. Therefore there was a clash between DPSP and fundamental right. And who were responsible to settle the dispute? It was the Supreme Court. And very interestingly, Supreme Court favor the fundamental rights. In Champakam Dorairajan case, you will be interesting to know that Supreme Court was favoring the fundamental right. Even then critics says that our judiciary is conservative. Because so many people, because after independence, people are judiciary elitist. Still there is criticism. And can you imagine the environment of after 1950s, when there was a influence of socialism, social justice. India was infant democracy, newborn democracy. Then people are saying that judiciary is elitist, judiciary is conservative. How judiciary protected fundamental right? How judiciary could overlook the DPSP? The question is that was the responsibility of judiciary, clause 2 of Article 13. Judiciary was there to protect the fundamental right. So obviously judiciary protected the fundamental right. And in that case, because it is enforceable, it is justiciable, but on the account of decision given by the Supreme Court in Champakam Dorairajan case, same time there is also clash occurred between the fundamental rights and DPSP in case of right to property. On the one hand, there was a clash between 15 and 37, 46, and there was a clash between Article 39 BC and Article 31 and 19. And in both cases, even Supreme Court was favoring the fundamental rights. That is the reason first constitutional amendment came, and first constitutional amendment was a major amendment which amended the fundamental rights. First constitutional amendment major, why? Because Why in that context first constitutional amendment came? Even if you look the first constitutional amendment act, what happened? Now parliament even restricted the fundamental rights. Why first constitutional amendment was very vital? Even in parliament, this was a heavy blow for the fundamental rights, not only for the Article 15. Clause 4 of Article 15 was added by the first constitutional amendment, which we have to see separately. And what clause 4 Article 15 says that paved the way for providing reservation for the well-being of a OBC or any section belonging to weaker section. Or clause 4 of Article 15 says that state can engage in the well-being of a socially and educationally backward class of citizens and scheduled castes and scheduled tribes. This was the clause 4 of Article 15. And not only that, so this was a very interesting, this was a very important restriction over fundamental rights. Therefore, what is the way? It means what is the way? If we want to change the decision of Supreme Court, we can exercise Article 368. Parliament exercise Article 368, and by exercising Article 368, Parliament amended the Constitution. Because Parliament is given, and you know that when Parliament amended the Constitution, Parliament worked like a mini constituent assembly. Who enacted Constitution? Parliament. I will tell you, Parliament has a two type of power. One is the ordinary lawmaking, legislative power, other is a constituent power. Once Parliament exercised constituent power under Article 368, it worked like a mini constituent assembly. And therefore, it was just like working. It was somehow recollecting the wishes of Dr. Ambedkar, Nehru. तो हमारे ये member of parliament उस समय just like they are reincarnating in form of Nehru, Gandhi and somebody else. और उसके बाद that was not only case. On the one hand, clause 4 of Article 15, and second, right to property was also restricted by the first constitutional amendment. I will tell you right to property later in 31. Right to property is further restricted. This was a restriction of a right to equality under Article 15. Then right to property was restricted because first time it was a Article 31A, Clause A of Article 31, Clause B of Article 31. Clause A and Clause B of Article 31, that was a very important restriction over right to property. And by Clause B of Article 31, 9th schedule that was added to the first constitution. It means our original constitution only incorporates the 8th schedule. 9th schedule was result of Clause B of Article 31. And 31A, Clause A of Article 31, Clause B of Article 31, it was restriction of Article 31. It was a heavy restriction of Article 31. And same time, can you imagine, this was a heavy blow. It means this was just like, if you look at the Hangama movie, Rajpal Yadav was under attack. So Supreme Court tried to protect fundamental right, but here it was a parliament, or it was just like a Russian army which is attacking over Ukrainian people. Fundamental rights means Ukraine. Parliament became Russia. And now you can ask the question that what was job of judiciary? Why we have kept judiciary? For protecting fundamental rights. But don't you think that judiciary was not able to protect fundamental right? Why judiciary could not protect the fundamental right? What happens with the bulletproof under clause 2 of Article 13? कमाल की बात यार. But उस पे आने से पहले, then further, it was also restriction over clause 2 of Article 19. Some further reasonable restriction were also imposed. Some further reasonable restriction, they were also extended. Therefore, freedom of speech and expression further restricted. Freedom of speech and expression further restricted by the first Constitutional Amendment Act. अब जरा सोच के देख लो. This first constitutional amendment that was the most important attack over fundamental rights. Otherwise, it was attacking over 3 articles: 15, Article Clause 31, and then it was a Clause 2 of Article 19, restricting fundamental right. Like if somebody is speaking against friendly relations between nation and state, inciting offense, public order, that will be not protected under the clause 1 of article 19 for freedom of speech and expression. अब जरा सोच के देख लो. अब इसका क्या हुआ? Once Parliament came with the first constitutional amendment, it was challenged in the Sankari Prasad case. Let us see. Can you imagine? In Champakam Dorairajan case, Supreme Court declared action of Madras government null and void on the what ground? Supreme Court, let us see, the Supreme Court adopted 2 yardsticks in the Champakam Dorairajan case. In the Champakam Dorairajan case, Supreme Court said that fundamental rights are more important, and therefore the order of reservation of Madras government that was declared by null and void, it was rejected. It was declared as ultra vires on account of violation of not only fundamental rights but also violation of clause 2 of article 13. Therefore reservation of Madras government that was declared null and void. But same time, the first constitutional amendment was challenged under Sankari Prasad case. First constitutional amendment was challenged under Sankari Prasad case in 1951. But can you assume what should be the approach of Supreme Court? What should be the approach of Supreme Court on the account of analyzing the verdict of Champakam Dorairajan case in the case in the case of reservation of Madras government? So what should be the likely outcome of Supreme Court in case of Sankari Prasad case? Can you guess that? Judiciary should protect the fundamental right. But you know that judiciary could not protect the fundamental right. Therefore, first constitutional amendment was attack over fundamental right, further attack over judicial review. Why it was attack over judicial review? Because you know that Supreme Court Parliament says that if we are carrying out land reform and any act passed by legislative assembly of a state, therefore we are able to put that act in 9th schedule. Again, I am repeating, 9th schedule was specifically maintained for the enacted for the Protecting Land Reform Act, only Land Reform Act. It is black hole, so nobody can fly over. Therefore, it was kept immune from judicial review. And in that case, then what was the role of Supreme Court? You will be surprised to know that in Sankari Prasad case, Supreme Court said that first constitutional amendment was valid. Why? Why? It means first constitutional amendment became valid, it became constitutional. So that is something very contradictory. If the reservation given by Madras government that can be declared null and void, then how first constitutional amendment can be declared as valid, constitutional? And therefore automatically DPSP became more important. Can you give the reason why? Because Supreme Court cannot give these type of logics. We have to remember, because Supreme Court, there is a difference between politicians and Supreme Court. Supreme Court cannot argue that only DPSP is more important than fundamental right, because this is layman language. Supreme Court has to give some technical ground, because Supreme Court know that it is a clause 2 of Article 13. That is some sort of bulletproof. ऐसा तो नहीं था, ये bulletproof Chinese था? ये Chinese था या कुछ और था? You know, the Supreme Court is a master of language. नया वेपन आ गया, कि नया वेपन कैसे आ गया? और आप देखो सुप्रीम कोर्ट ने कहा क्या, you know that Supreme Court said that once we read out fundamental right, then some landmark cases are there, like Shankari Prasad, then Golaknath, Keshavanan. They are very landmark, because they are still impacting our political democracy as of now too. Therefore, what happens under clause 2 of Article 13, you know that in clause, Supreme Court reinterpreted clause 2 of Article 13. Yes. Therefore, Supreme Court says that it is a clause 2 of Article 13 includes law. Any law which includes the fundamental rights cannot be declared as any law which includes the fundamental right shall be declared null and void. But the question is which law? Ordinary law or constitutional law? Which law should be declared null and void? Because you know that there is a difference between ordinary law and the constitutional law. Constitutional law is enacted by Parliament under Article 368, and that is special power of Parliament. That is in Part 20 of the Indian Constitution. And here ordinary law, that is enacted by both assemblies as well as Parliament under Article 245 and 246. 245 says that law made by Parliament shall be implemented throughout the country. Even Parliament has a power of making a law which is extraterritorial in nature. Article 245 says extraterritorial means if Uttarakhand government made a uniform civil code, that is only valid for Uttarakhand, not for the entire territory of India. But if Parliament is making a law, that is valid for the entire territory of India first. Second, that is Article 245. Our Parliament can make a law for the people of belonging to India who is residing in US, NRI. Even Parliament can make a law for non-resident Indian. ये भी तो law बना सकती है Parliament. And that is known as extraterritorial. And same time, Article 246 tells about the list: union list, state list, concurrent list. Parliament is entitled to make a law over union list, then state is a state list, and then concurrent list that is available for both. Resolutory power belong to the union government, and that is the point. Ordinary law needs simple majority. Ordinary law means that is required by 245, 246, and that is a constitutional amendment act requires a special majority. A special majority means majority of strength of house plus 2/3 majority of present and voting. Both condition must apply. In that condition, therefore, are you recognizing Madras government, law enacted by Madras government, that was an ordinary law. The law enacted by Madras government was ordinary law and therefore against the clause 2 of Article 13. Because clause 2 of Article 13 means, refers ordinary law. Refers, indicating ordinary law. But it is not referring constitutional law. So that is point. First time Shankari Prasad said that there is a difference between ordinary law and the constitutional law. And therefore restriction imposed by clause 2 of Article 13 is applied over ordinary law, not over constitutional law. What automatically means, by constitutional amendment, Parliament can amend any part of the Constitution. Remember, any part of the Constitution, including Part 3. Because of that reason, now Parliament was entitled to amend any part of the Constitution, because Article 368 is the constituent power of Parliament, a special power of Parliament. And that is the point. By 1967 onwards, even Supreme Court accepted this judgment. But suddenly what happened after 1967, that we will discuss separately. Now Parliament got an opportunity, and thereafter Parliament implemented DPSP for sake of well-being of the people, for implementing the idea of welfare state. और ये भी आप देखोगे, the election was likely to be held in 1952. Justice Patanjali Shastri, Justice Kania, so many people asked to them, oh my God, Mr. Judges, you're unable to protect fundamental right. But they replied that, oh my God, we are protecting fundamental right, but fundamental rights and DPSP, they should not be seen in the contradiction. And if Supreme Court is exercising the Article 32, then how we can snatch Article 368 from Parliament? There should be balance, harmonious construction. And that is point. There is a limitation. There is a limitation put over every organ of the government. Separation of power. And that is point we are respecting. And that was really, when Nehru was the Prime Minister, there was very fine balance between Parliament and judiciary. Parliament never criticized judiciary. There was a disagreement. Disagreement is part of democracy. This was story behind first constitutional amendment.